Okay, good morning. It's Friday, so it's construction question time with Brandon Silver. So Brandon, good morning to you.
Morning, Julie.
How are you?
Yeah, I'm good, thank you. How are you?
Not too bad. So you're going to be answering another one of those frequently asked questions that we get in construction. So this week you're going to be explaining to us what is the difference between patent and latent defects and what rights does an employer have upon discovery of such defects? Do tell.
Yep, so thank you for that introduction, Julie. So yeah, today I'm going to talk about patent and latent defects. Before I go into further depth about the differences between the two, I think it's just important to note that this is one of the most common disputes that we get between a contractor and employer dealing with alleged defects in the works. So just to clarify what a defect is first, before I then go into what a latent and a patent defect is. A defect is when the works are not in accordance with the contract. So I'm now going to talk about two different types of defects. So the first defect I'm going to talk about is a patent defect. Now, a patent defect is a defect which is clearly obvious and can be found upon reasonable inspection of the works. So examples of this would include broken windows, missing tiles, cracks on the wall, or, for example, a contractor forgetting to install an AC unit, which under the contract it was required to do. All of these examples are examples of defects which are not in accordance with the contract, therefore is a defect. And because they're clearly apparent upon an inspection of the works, they would be regarded as a patent defect. Now, the other type of defect is a latent defect. Now, a latent defect is a defect that is hidden or concealed. So, although it does exist, the problem with it is that it is not apparent upon completion of the building works. So let me now go over some examples of what latent defects would be. So latent defects would be inadequate foundations leading to subsidence of the building. It would also be mold hidden under carpet, and it would also be incomplete ductwork, which is behind walls. You can see from all of these examples that it's not clear from the completion of the works that these defects occur because they're all hidden, and it may be the case that these are only actually found out to be defects and that they actually exist years down the line. So having now distinguished the differences between the two, what most commonly occurs is there's going to be a construction dispute between the parties as to the nature of defects and the responsibilities of the parties in terms of rectification. So what does the employer do if there is a patent and a latent defect? Well, once identifying it, I'm now going to go through what to do next. So firstly, with a patent defect, what the employer can do very much depends on when the patent defect is found out to be a defect, that they actually understand the nature of it, and that they notify the contractor. So if this is before a certificate of practical completion has been issued, then what the employer should do is not issue a certificate of practical completion until the defects have been rectified by the contractor. However, what can occur is that certificate of practical completion has already been issued, and only after that does the employer then notify the contractor and find out that there is a patent defect with the works. So what should happen here is that it would fall under the contractual defects liability period. Now, what is this? Well, this is a period that begins upon certification of practical completion and usually lasts a period of 6 to 12 months, however can vary depending on the terms of the contract. Now, what this provision provides is that within this period, if the employer notifies the contractor of a patent defect, then the contractor is under an obligation to rectify this defect at its own expense. Now, this is a contractual entitlement of the employer that the contractor must comply with, and the motivation for the contractor is that, of course, the employer will be holding a retention at this time, and that retention will only be released once all defects under the period have been rectified, that have been notified. Now, it's a little bit more complicated with latent defects. As you can imagine, given the description and definition I've given of latent defects, it is normally the case that a latent defect would only be identified and discovered after the end of any contractual defects liability period has expired. It'd normally be after the 6 to 12 months because, of course, it's not apparent at the beginning. Now, if it falls outside of this contractual defects liability period, so it's not notified to the contractor until afterwards, then there is no contractual entitlement for the employer to require the contractor to rectify it at its own expense. However, what the employer can do is seek an action against the contractor for damages for breach of contract or negligence. So that's the claim that you would bring against the contractor for the latent defects. Now, the important thing to note now is that these rights, so to bring certain claims, there is a time limit to which you can bring the claim. They're described as not being perpetual. They're not lasting forever. So what I'm now going to do briefly is just explain the time limits for bringing such claims. So if you're bringing a breach of you're bringing a breach of contract claim for damages or a claim for negligence, then if it's under a simple contract, then you must bring the claim within 6 years. However, if it's a contract executed as a formal deed, then you have slightly longer, well, double the amount of time, you have 12 years. Now, as a side note, if you have any questions in relation to this and just want to know the differences between the two and whether a contract you've entered into is either a simple contract or executed as a formal deed, then please do not hesitate to contact me about that. So just returning now, obviously I've just mentioned it's 6 years and then it's 12 years depending on the type of contract. There is, however, an important extension of time to bring a claim if you're bringing a claim for negligence in relation to latent damages. If that's the case, then there is an act which provides as follows: that you can bring a claim, the time limit for bringing the claim is the later of 6 years from the date of the action that the cause of action has accrued, and 3 years from first knowledge of the cause of action, subject to an overall limit of 15 years from the act of negligence giving rise to damage. So this provides a longer time that you can bring such claim to reflect the fact that it's latent damage, latent defects, and that of course it's going to not necessarily become apparent to the employer until much later. So I've now finished what I was going to talk about. So that was patent and latent defects. If you have any questions in relation to any defects that you believe you have found to be apparent and you don't know if it's patent or latent defects and what to do next, then please do not hesitate to contact me and I'll be happy to help. Thank you.
Great, thank you for that clarity, and we look forward to next week's questions. So we'll see you next Friday, Brandon. Take care, stay safe. Bye-bye.
Bye.